United States v. Evans and the case that you cited, United States v. Jackson, it does state that in order for the Consolidated Appropriations Act to be applicable to my situation, I would have to strictly comply with the state laws regarding use of medical marijuana. Now, schizophrenia in the state of Florida is not a qualifying condition which somebody can use medical marijuana, in which case any attempt by the probation office to manufacture a false diagnosis of schizophrenia militates directly towards that point where they are alleging I am not in strict compliance of the medical use of marijuana.
Your Honor, Jose Arteaga from the government. May I be heard on the bifurcation issue, because I think the court is not using the proper controlling authority that governs this very specific issue. The Supreme Court case that is on point that controls this issue is Gonzalez versus Rape, and that's the last name. That last name I mentioned is A-R-A-I-C-H. It's a 2005 Supreme Court case, 545 U.S. 8-1. That is the controlling case on this issue. In that case, which was cited by Judge Kearney here in the Eastern District of Pennsylvania last year in a reported decision, which is that decision is United States of America versus A-E-E-Y, and that's 341. I have that right in front of me. Okay, if you look on page 530, the Supreme Court in Gonzalez said marijuana is contraband for any purpose. Congress expressly found that the drug has no acceptable medical use. Now, that Supreme Court case, Your Honor, reversed the United Circuit case that held that that marijuana qualifies as a medical necessity defense and was legally cognizable in the Ninth Circuit. The Supreme Court reversed it and held that a medical necessity exception for marijuana is at odds with the terms of the Controlled Substances Act. So I do not believe that this proceeding ought to be bifurcated.
Your Honor, the government cited Gonzalez v. Raich, and I'd just like to read directly from the Supreme Court opinion in that case at 545 U.S. 33, and it states, respondents also raise substantive due process claims and seek to avail themselves of a medical necessity defense. These theories of relief were set forth in their complaint but were not reached by the Court of Appeals. We therefore do not address the question of whether judicial relief is available to respondents on these alternative bases. So the Supreme Court did not foreclose of a medical necessity defense for medical marijuana. And additionally, in U.S. v. Oakland Cannabis Virus Co-op 532 U.S. 483 and 121, they similarly state a distributor of marijuana did not have a medical necessity defense. But the court expressed the view that an instant case did not require the Supreme Court to rule on the scope of the district court's discretion to enjoin or refuse to enjoin the possession of marijuana by a seriously ill patient for whom the drug might be necessary. So I'd just like to make sure that's on the record.
That to me seems to address a different issue than the issue we have here. We're not attempting to prevent anybody from cultivating medical marijuana. The problem is we have a defendant who's federal supervised release who is using a controlled substance that is still illegal under federal law.
Right. Well, I cited in one of my pleadings to Your Honor, United States v. Robertson, 367 Fed APPX 301, and that was actually a Third Circuit case that dealt specifically with the fact that in the Western District of Pennsylvania, they routinely deny probable cause hearings, and the court made it a point to state that that type of procedure is not appropriate, and they raised also United States v. Companion, which I raised in my prior pleading, 545 F2D 308, and that why I'm bringing this up is because technically the entirety of the hearing should have occurred in the Southern District of Florida, the District of Arrest, and now I'm being hauled off to another jurisdiction entirely that I have no ties to, that I have no friends, no family. I'm being separated from my own family based on impermissible factors such as my race and my religion, because that's the reason that Southern District of Florida all of a sudden has decided that they don't want to extend a courtesy to me that they extend to everybody else who has a favorable race or religion to the ones that they follow. And that's why I'm raising an objection to being hauled off to Pennsylvania under those terms and for those reasons. I have done nothing wrong here. I haven't violated my probation. And really the only thing I was complaining about with the Southern District of Florida is their manufacturing of falsified medical diagnoses against me and the refusal by everybody to allow me to challenge it, because a forged schizophrenia diagnosis devastates my life in ways that the court doesn't see. And I'm the one who deals with that once those reports are written. So the only reason why all of a sudden Southern District of Florida is attempting to withdraw the courtesy that they provided me is because I've challenged them and demanded that they either allow me a hearing to dispute the forged reports, to have them removed from my file, or to have them removed. And because I filed a lawsuit complaining about that, they retaliated against me by now trying to ship me off to a foreign jurisdiction where I have no ties whatsoever.
When I spoke to the probation officer,